SJC-12607, Commonwealth v. Ryan K. Harris.
Good morning.
Good morning. May it please the Court. Christopher DeMeo for Brian Harris. I'm going to try and focus today on the 3 points I put in the DAR application, which are putting the burden on the defendant to show evidence of a gun license. Number 2, state law restrictions on entering the state with a handgun without a Massachusetts license. And number 3, the federal statute 926A. So the first issue has been addressed by this court several times, so it's my hope in this appeal to say something a little bit new. The issue here is that under the statute 278 section 7, this court has said a defendant is required to produce some evidence of a license, which I think usually means a license, and that if he does not do so, the way the jury instructions are written, that element is simply omitted from the crime. So the way this was dealt with in the past, starting in the Jones case back in the 70s, as the court said, well, that's okay because to convict of a firearms violation, you need to prove possession of a functioning firearm. So in that case, that was back before the Second Amendment applied to the states, and it was quite all right at that case to compel a defendant who's sort of getting a gun as a matter of grace, legislative grace, not right, to come forward with some evidence that he has a license. And we'd submit that is not the case. It's no longer the case that this court could say, and this court said very clearly in Jones, there's a general prohibition on handguns. It's a general prohibition. And to bring yourself out of that general prohibition, you have to come forward with a license. It's sort of like treating a gun like a drug, like cocaine. I think doctors, and I think certain drugs you can have licenses for if you have all the DEA stamps and everything. And in that case, it would truly be affirmative defense because drugs are contraband. Up until 2010, the states could treat guns as contraband. They can't do that anymore. You can't treat a gun as a drug, as contraband. It's the opposite of contraband. It's enshrined in the Constitution that you have a right to have a gun. So I would submit that for the same reason, all the cases where this court has said production of a license is an affirmative defense, those cases should be overruled. I would.
Let's assume you're right. How would the Commonwealth prove it?
Well, since it's 2018, I'm assuming that somewhere there's someone who can push a button, and then at some point, I think probably I will acknowledge someone's probably going to have to come into court because someone's probably going to have to testify that this person they duly ran the test. It would be testimonial because it would be for the criminal case, so I think it would be testimonial under Crawford. They would have to come in and say he wasn't on here. I think you could probably stipulate to it a lot of times, which is why I kind of didn't.
Stipulate, but I mean, so a person lives in Burlington. You'd have to go to the Burlington PD and say, do you have any record of Mr. Smith having a license? Answer, no. But then maybe he had lived elsewhere. I mean, these licenses are given by the police chiefs, correct?
They are given by the police chiefs. I'm going to defer to my sister on that because I don't really know. It's 2018. If this state doesn't have some kind of system where they can figure that out in a computerized way in order to comply with the Second Amendment and due process, then I think that's a bad thing for the state. But I'm not arguing. I don't really think some of the old cases talk about the relative ease of the parties, and certainly that if I have a license in my pocket, it's easier for me to pull it out. But that, I would submit, doesn't come into play under the analysis I'm giving, so it's up to the government. I think, I find it hard to believe that there's not a state agency that could figure this out in a somewhat efficient manner. But I did want to say one more thing on affirmative defense, to say it a little differently than I said in the brief. According to Black's Law Dictionary, an affirmative defense is a defendant's assertion that raising new facts and arguments that, if true, will defeat the plaintiff's or prosecution's claims, even if all the allegations in the complaint are true. So the reason this is no longer, so back in 1970, during the Jones case, a license was indeed an affirmative defense because it was a new fact, as Black's Law would say, that excuses you or defeats liability for the claims in the complaint, which are just possession of a firearm. But that can't be the case today.
But even under the Heller paradigm that you talk about in the sea change, the Heller and McDonald all state that the state can regulate, of course, firearms.
Of course,
right?
yes.
So, and what this state does, and most states do, and you can't, and then the prohibition is against a ban. So what this state says is we're going to regulate firearms. In order to lawfully possess a firearm, you have to go through the licensing process.
Yes.
How is that different from what the prior law was? How does Heller change that? So now that we say we can regulate to lawfully own a firearm, you have to have a license. Now, if you are charged with a possession of a firearm, the burden on you is to show the license to raise this affirmative defense.
Because in Jones, this court said the crime is possession of a weapon, and now the burden is on you to pull yourself out of that, to produce a new fact, which is the license. The crime can no longer be possession of a weapon. The crime has to be possession of a weapon without a license, or possession of a weapon while you're a felon or whatnot. That's now it has to be an element of the crime. It has to be an element of the crime. And you cannot, an affirmative defense cannot be put on a defendant to meet an element of the crime. Now, certain presumptions can, and we concede this in the brief. There's the presumption that one in possession of stolen goods is a thief is a presumption. It helps the government meet its case, even though one of the elements of theft is knowledge. But the reason it was allowed in the Barnes case by the Supreme Court is, first, it's a very old presumption going back to colonial days, but mainly it's permissive. It's a permissive presumption. It only gets such weight as the jury feels it needs. This is not a permissive presumption. This is tantamount to a mandatory presumption. If I don't come forward with the license, it's not even mandatory. The judge doesn't say you have to find this. It's simply omitted from the jury instructions. The element is struck off. It's the equivalent of the government getting a directed verdict on that particular element of the crime. And judges can't enter directed verdicts for the government in criminal cases. So that's the gist of that argument. I'm going to talk about handguns across state lines unless there's any questions on that point. Okay, the next argument relates to the whole scheme here. So there's 269, which outlaws carrying firearms and possession of firearms. And there's a whole bunch of exemptions in Chapter 140. The exemptions allow rifles and shotguns to come into the state in transit, and if you have a license in another state, you're even free to possess them and carry them around. No exemption for handguns, which Heller says are the quintessential self-defense weapon. There were originally, I tried to do a little legislative sleuthing, which I put in the back of the big brief, the principal brief. In 1968, it said firearms. It was amended the following year to rifles and shotguns. I couldn't see any basis for why that happened, anything in the history. I didn't see anything in the red brief or the green brief to explain why that happened.
What's in the Commonwealth brief is that there's a federal statute and a supremacy clause.
Well, there wasn't a federal statute back in 1969,
No,
but there
no,
is nowadays, yes, certainly.
Statute.
And I take that to be kind of a concession that the statute is by itself unconstitutional. But Mr. Harris wasn't convicted. Mr. Harris was convicted under 269-10. So when Attorney Krasnow brought this motion to dismiss before Judge Pearson, he was alleging the constitutionality of the statute that he would be tried under, and that he would be convicted under. So I don't see how it's any answer to say that, well, there's other federal statutes out there. No law was cited for this idea that you put all the laws together and consider the constitutionality of all of them. And they're not even the same exactly, because according to at least the AG in the Green Brief, she says that you have to go through 3 different states in order to get the protection of the federal statute, whereas the state statute, if it applied to handguns like it applies to rifles, it just says traveling in or through. In this case, Mr. Harris was in Londonderry. So if you're over on the west side of Londonderry by Hudson, the quickest way to get home is often to go down Route 3 over to 495 and up 125, which brings you into Massachusetts. So I submit that and I appreciate there's a whole side issue of, he stopped at his girlfriend's, and did he stop for too long, and does that bring him outside of the protection? But putting that aside, because this is a facial challenge, brought up the motion to dismiss stage. He clearly could have, if handguns were covered, like we certainly should have, he could have been able to take the very reasonable step of getting back to his house via 495. And I give lots of other examples. I mean, you can look at, if you're in the Texas Panhandle and want to.
So I'm just trying to make sure I understand what you're arguing. Are you arguing that because he's licensed in New Hampshire, he's got to be able to briefly enter into Massachusetts as he drives to and from work or to and from business? Is that your argument?
That is my argument, and it's premised on a few things. It's premised on the Second Amendment, and I'm assuming in here the Second Amendment applies outside of the House. I will just say that openly. There may be.
How does that intersect with the grace period? I just want to make sure I understand that, because if you have a 60-day grace period if you move somewhere, but I take it you're saying this falls outside of that too, right?
Well, the grace period issue was sort of a factual sub-issue. I don't really think it was an issue at all, but yes, I'm conceding, and well before 60 days are out, that if you spend enough time in a state, that the state has an interest that then attaches to you, and they can start regulating your conduct. But my argument here is that under the Second Amendment, under the right to travel, the statutory scheme as a whole, 269-140, needs to make some exception for someone, and Mr.
I'm still confused, though. I appreciate that, but there is a law that says that somebody can go from one state to the next if they're going directly and have that firearm. It's the federal statute.
That is true.
926A or whatever it is.
I agree, yes, and that's my next point. If I have time, I will get to. But I'm disagreeing with the government's position that when you analyze the constitutionality of a state law, that you also look to the federal law, and it fills in the gaps. I put in a footnote where I said, could you outlaw public assemblies, and then say, well, that doesn't violate the First Amendment, because we are really going for like rowdy public assemblies, and the First Amendment allows peaceable assemblies. That seems to me to be exactly what they're saying here. We can just pass any kind of law, it can be unconstitutional, and the federal law will fill in the gaps or will supplant it under the Supremacy Clause. I don't think that's the law. I didn't see any law cited to that. But also, as a factual matter, as I'm saying, I don't think if they're saying, the government is saying 926A requires you to go through 3 states. I disagree with that. But if that were the case here, then that's not what happened. I just said he went down.
But are you arguing that 926A, basically because he's licensed in New Hampshire, if he's just sort of making a brief excursion to go from New Hampshire back to New Hampshire and he somehow crosses the border, 926A protects him? Is that what you're...
That is exactly my argument, Justice Kafker. And what I'm saying here is it should not... If a police officer sees you at a gas station or something with a handgun in your car, it shouldn't really turn on intent. You shouldn't say, if I'm going back to New Hampshire, I get arrested. But if I say I'm going to visit my aunt in Maryland, where they have reciprocity with New Hampshire, then you're okay, and I'll send you on the way. It should basically be, until the police the government has some reason to believe that you've been in a place a long enough time that there's a factual question whether you're actually moving the
But
gun.
that's not our case, right? Our case really is he's knowingly coming into Massachusetts first. He's not just doing sort of a cut through because he lives on the border, but he's actually coming to Massachusetts to stay with a woman who he's spent over 90 days with, right?
Well, the 90 days, again, is a side. So what I'm arguing is that this is a defense. 926A is a defense. He was entitled to a jury instruction on it. When you're entitled to a jury, whether you're entitled to a jury instruction depends on the facts favorable to the defendant. And he denied it. He testified. He denied the 90-day thing. But in particular, I agree there's a factual issue because he said she didn't return his text. He went to stop off the Tewksbury's on the way on 495, but he stopped off. But yes, if he stayed long enough, this might not be in transport. But what Judge Coffey said is,
But he's not just going to one place in New Hampshire to another place in New Hampshire and crossing the border. He's going to Massachusetts deliberately, right?
he's
And
going deliberately.
And he's not licensed in Massachusetts. So I just don't know how 926A applies.
I'm arguing that he was transporting the gun as long as it remained locked and secured with the lock through it and unloaded in his trunk. He had the gun in transport, and I concede that if you stay around long enough in a particular place, and the evidence doesn't show he was there more than a half hour, an hour. They had a fight, and she went and called the police. I agree, yes, if you make a long excursion and he decided to go to a movie or something, then you might get into factual issues, but it's a factual issue. Judge Coffey said, I'm not giving the instruction, and it was erroneous, we'd assert. It was prejudicial because he was in Massachusetts with a gun without a license. So
The judge only has to give the instruction if it meets the definition of the statute, and the statute says allows for transportation of a firearm for any lawful purpose from any place where the person may lawfully possess and carry such firearm to any other place where he may lawfully possess and carry such firearm. But he's not doing that here. He's going from a place where he can to one he cannot, right?
he was at a shooting range in Londonderry, and then he went back to his house in Atkinson. And yes, and that's what he was going to do if he had completed his trip. He stopped at her house. I don't think the statute, and I put this in the beginning, in the first brief, it doesn't seem to me to imply you can't stop at all, because what if I'm going on a hunting trip in Montana? Of course I'm going to stop, I'm going to have meals, I'm going to go into a hotel. It's not really clear to me under the statute whether you have to leave the gun in your trunk the whole time. That's exactly what he did. He was there no more than, a half hour, an hour, whatever the police report and record shows. The gun was in his trunk the whole time. He was planning to move on. So I'm asserting it was a factual question whether he was still in transport. Transport means moving the gun along in commerce. I'm not saying he was entitled to a Lattimore directed verdict. I'm just saying Judge Coffey ought to have given the instructions, which was, and that was a key part of his defense because of the way he was found in Massachusetts with the gun without a license.
All right,
Thank you.
Ms. Mastrangelo.
Morning. May it please the court. Ashley Mastrangelo for the Commonwealth from Middlesex County, and for the record, I was the trial prosecutor in the case before the court this morning. The defendant challenges this conviction on a few grounds, and first states that the regulatory scheme employed by the Commonwealth, which requires people who want to carry firearms outside of their homes, obtain a license, is unconstitutional. I'd ask that this court continue its well-founded logic that that is not the case. The defendant really rests that argument on that fact that the Commonwealth should also have to prove a negative. So the Commonwealth should also have to prove that someone is not licensed. This is best explained in the burden of production arguments. So the burden of production is what is on the defendant, and that is something that is not unconstitutional. And the reason that it is because that would be something that is in their ability to easily produce, and that comes from even a lawyer having to produce a law license. So the Commonwealth, the way that the Commonwealth regulates firearms is by that license, and it's not an element of the crime. So we've not shifted the burden beyond a reasonable doubt to the defendant. We've only shifted the burden of production because a license would be an affirmative defense. Surely if the police had stopped Brian Harris that night, so they did. They stopped him and they said, "Do you have a Massachusetts license to carry?" And he said, "No." Had he produced a Massachusetts license to carry, I doubt that we would be before your honors this morning. So the defense wishes to put that additional burden on the Commonwealth to create a database or create something that isn't hearsay at a trial to bring in to prove a negative, when the burden of production placed on the defendant would simply clear that issue. And I'd ask that this court continue its legacy of holding up Jones. And I also think that affirmative defenses are well explained by the appellate court in Commonwealth versus Grafton, that they are, and I believe they cite Farley in that case, that an affirmative defense involves a matter of justification, particularly within the knowledge of the defendant on which he can be fairly required to adduce supporting evidence. So I would ask that you affirm the Commonwealth's right to regulate firearms, which is extended by Heller. Heller explicitly states that the states can regulate it from certain classes of people who would be exempt from that.
Can you help me with a matter that I'm perplexed by?
Yes.
A particular defendant is courting somebody, brings a gun into Massachusetts and is found with it without a license. He may be charged and convicted, correct?
Yes.
If that same person comes in and says, well, actually, we're living together, and I just moved in yesterday, I've got 60 days, or is it 30 days, to get a license, he's not convicted.
Well, so I think that it would be very fact-specific in that instance. I think, so the Commonwealth maintains, of course, in the case before you, that the defendant was living here over 110 days.
Right. I mean, I understand why this person may not necessarily be eligible for that exemption, but it's a little bit strange to me that if you're just visiting for a few hours, you are guilty, but if you say, well, I'm moving here, you've got 60 days to get a license.
Well, I think in order to answer that properly, I would look to additional factors in that scenario. So in this particular instance, the gun is found in his car. It's not found in the residence. So of course, going to the carrying. And so in your example, where he would be in the home with her when he's found, where depending on where the gun were found, if there's other indicia that he may be living there, the police could conduct that investigation and perhaps come to that result, or that he had alerted the chief of the town that he was moving there and intended to take up residency. And Massachusetts does allow for temporary resident permits, even if he were just going to summer here. You can apply for one with the chief of that town. So there are remedies available, but the onus is on the person to take steps to ensure that they are lawfully carrying that firearm, especially outside of the home. That answers the question. But I would move to the second point.
On the same line, so, you know, someone lives on a border town, and he's got a license to carry, and he's driving around, and his Waze directs him across the border in a faster way. He's liable for what, 2 years? I can't remember the penalty here. Is he guilty and subject to, what is the mandatory minimum for this?
18 months.
Is that right?
I believe the minimum mandatory is 18 months.
So just in my example, you live in Pawtucket or wherever, you live right on the border, and you sort of cross over as you're driving around, and you get pulled over. You've got an 18-month mandatory minimum.
Well, I mean, assuming a few additional facts, I don't think that that's what's present in this case, though, because...
I agree it's not present. I'm just trying to understand sort of, there's no I mean, I take it there's prosecutorial discretion, but that's what we're going to have to rely on.
Well, there's prosecutorial discretion, but then there's also the trial judge and motions to dismiss and, you know, additional evidence that would be presented to a jury, or, you know, there are additional affirmative defenses in that particular scenario.
Like what?
Well, if there were additional indicators, perhaps. I mean, if someone is living in Pawtucket and their Waze, in this example, their Waze directs them through Attleboro, which is not very far. It's maybe one exit on 95. And they are going, just going back into Rhode Island. Well, when they're stopped by the police, what is their driver's license? Do they have a Rhode Island driver's license? Do they have any registration paperwork stating maybe their home address or?
It's no defense though, right? You're still screwed.
Well, I'm not sure that even there would be, if all of those things were present and the gun was safely contained in the trunk, et cetera, and you had those other indicia in that scenario, then it would be very easy to say whether or not the person was truly just, was their GPS, could the police officer see their phone with their GPS, open?
But doesn't all that go to the officer's discretion, not the actual law that would permit this?
Well, I mean, I think
It would be a silly thing to prosecute somebody for. That's what you're arguing.
under that example, it would be, I would
But
assume,
that would
egregious
not
of prosecution at that point.
Preclude a police officer from doing that should they choose to. They would be completely in compliance with the law if they charged and then prosecuted that way.
In those facts, yes, the Commonwealth would concede that point, but because it has to. Because without that, the Commonwealth would not be regulating the flow of weapons over its borders, because
And
that's really what this is.
Is there any way, I think one of the purposes of this law was to make sure you could reach people who are trying to sell guns or traffic in firearms in our state, who are coming in to do that. So is there any way to regulate them or prohibit that without bringing in the person in Rhode Island who's just, gotten off the wrong exit or is going home to work through Attleboro?
Well, I mean, I'm not sure I could craft something articulate, that would supplement that. But I think if, in looking at just the plain example, and especially in looking at 926, which it's legislative intent, and I think that's well laid out in the amicus brief. The whole point of 926 was to allow people to go from.
Doesn't that just prove that the AG's interpretation is wrong? That you have to go from New Hampshire to Rhode Island, and if you're going from New Hampshire to Massachusetts to New Hampshire, that's enough to satisfy 926? I mean, your argument you're making, which I agree with, just says that the AG's position is wrong. Sounds like you agree.
Then perhaps I maybe misspoke, Your Honor. So in this.
You're about to say that 926 would save you in that situation.
Going from Rhode Island back to Rhode Island?
Right.
No, it would not.
I thought that's what you were about to say.
No, I was sort of transitioning, but I think that, it certainly, the legislature could, craft a provision, I suppose, but it would be almost impossible to do on those facts. The Pawtucket through Attleboro back to Rhode Island scenario.
That's why I think the AG's, that makes no sense to prosecute that person. And
Right.
so 926, from any place he may lawfully carry a firearm, that's Rhode Island in this situation, to another place where he may lawfully carry a firearm. The other place is back to Rhode Island once you're in Massachusetts.
I don't agree that you can go from your home state through a state back to your home state. You're not really traveling, and I think that is laid out through the intent and spelled out that it's to any other place. So no, the Second Amendment does not entitle you to live in a border town and go through Massachusetts with your firearm, carte blanche whenever you want.
Go to McDonald's?
I'm sorry?
You can't go to McDonald's? Not that I would ever go, but you can't go to you can't go to McDonald's? Like, so if you live in New Hampshire and you went at the shooting range and you're hungry and you go across the border to McDonald's and you come back to New Hampshire?
A person could, but its firearm could not.
You violate the law?
The New Hampshire license, and going back to sort of the facts in this case, a New Hampshire license entitled the defendant to carry his firearm in New Hampshire. It did not entitle him to carry it in Massachusetts. And, it's stringent for a reason in that otherwise someone could always be saying, oh, I was just going to McDonald's and I live in a border town. That could always be the excuse for carrying weapons without a license inside the Commonwealth.
And then if we look at your position, the AG's position, it's okay, though, if I live in New Hampshire and I'm driving to Montana to go hunt big bear or whatever, right?
It's an affirmative defense that you could raise, yes, because the point in the legislative intent, and I think it's detailed well in the amicus brief, it's to be able to go from South Carolina to Maine by way of New York to go hunting. And you're lawfully licensed in South Carolina and you're lawfully licensed in Maine, and so you're gonna take that gun through New York, and you would have an affirmative defense under 926, assuming, of course, it were unloaded and in the trunk and you met all the other statutory provisions, because in the express language of the statute, it's one state to any other state. And I think the legislative intent is clear that it was meant to be a safe harbor for travelers, so as not to completely impede someone from going through states to get to another one with their firearm in those jurisdictions where they're both lawfully licensed to keep it. But that is for the purposes of travel, and those circumstances are narrow for a reason, and the defendant was not entitled to that jury instruction because that's not what was present in any view of the evidence. I mean, certainly in the Commonwealth's view of the evidence, he was living here. But in the light most favorable to the defendant as to whether or not that jury instruction ought to have been given, Justice Coffey was correct, because in the defendant's view of the evidence, and I believe it was page 190 of the transcript, in his own words, he left New Hampshire that night to go to his girlfriend's home because she wasn't returning his phone calls. And he brought that firearm with him.
What if he left New Hampshire, because she wasn't visiting, she wasn't returning his phone calls, but he knew he wasn't invited to stay over, so he was just there to go have a conversation and drive back. Would he be entitled? I know you don't think he's entitled to the instruction, right?
I don't, no.
And if that statute were to apply to sort of these kind of round trips where you're just, making a pit stop, basically, would he be entitled to the instruction?
If 926,
If 926 allowed Justice Gaziano to go to McDonald's if he wanted to, and then came right home, would he have been entitled to the instruction then?
perhaps if that's what it allowed for, but I think that it very clearly doesn't, for the reason that the intent of the trip would matter, right? So you go from New Hampshire to McDonald's in Massachusetts and then back to New Hampshire. That doesn't fall under 926 because you're not really transporting your firearm for a lawful purpose. You want to go into Massachusetts, and you're free to go into Massachusetts. You're just not free to bring your gun with you at that point. The whole point of 926 is for the ease of people to be able to, take their guns to a gun show or to hunting. The purpose and the intent of that trip matters.
And we find that in the legislative history that's been cited.
I'm sorry?
And we find that purpose in the legislative history that's been brought forth in the brief, right?
And I think the amicus brief does a wonderful job of exploring that legislative history, that's actually exactly what the senators were debating and deciding. And of course, I think in the amicus brief, it does a good job of showing the original version, which stated for interstate commerce, and the legislators sort of felt that was too broad, and that it would sort of create this lawless ability, that the Second Amendment would just be take your gun anywhere, and what would be the point of regulating it state to state. And they said, okay, let's narrow it slightly. It's from one state to another state.
I'm not sure my geography is going to work, even though I have it up on my iPad. So you live in East Texas, and you want to go hunting in West Texas. So the quickest way might be to go through Oklahoma a little. You got to go 5 hours out of the way to go hunting so that you don't
All
violate.
okay over there.
Assuming that we put that factor aside.
As Justice Seifert correctly said, I'm not sure what the laws would be in
That's a
Texas.
good safe harbor.
I don't want to speak for the state of Texas.
It makes no sense that you'd have to go 5 hours out of the way.
And in that particular scenario, it may not be at issue. Massachusetts, in this particular scenario, the point of the regulation, the compelling state interest, as it were, is safety. And the way that we regulate safety is by regulating the flow of weapons through the Commonwealth's borders. And that's what we must do.
I guess the real question, though, is if it is only through one state, so if you could go to McDonald's after the shooting range and then go back to New Hampshire, if 926 covers that, in the light most favorable to the defendant, in this case, would the defendant have been entitled to that instruction?
If 926 allowed for you to drift into another state briefly and drift back into your home state, yes, if those facts were present, yes, he would have been, but I don't think in any view of the evidence, and certainly not even in the defendant's view,
In
he
the
was
light
entitled.
most favorable, not what could have happened, what happened in this case during the trial, assume 926 applies if you're going from New Hampshire, McDonald's in Massachusetts back to New Hampshire. if 926 covers that situation, contrary to the AG's view, in the light most favorable to the defendant, would the defendant have been entitled to the defense under 926 in this trial?
Yes, if that's what 926 covered. Although I think, again, in the express language, one state to another state, it does not.
And if he had wanted to get a Massachusetts license as a visitor, what's the process?
So he could have applied for a temporary resident permit, or, and I don't remember how many
For a
days.
resident, let's assume he was just visiting. Let's put aside whether he was a resident. Let's assume he just was somebody in New Hampshire who wanted to be able to bring it into Massachusetts periodically. Perhaps he worked here.
Right. So there are provisions in Chapter 140, and I'm not sure which exact section it is, but there is a provision in Chapter 140 where you can apply for a temporary permit in Massachusetts. I believe it is a temporary resident permit that would allow you to be here or to summer here or to come here. But I think it's sort of this difficult area between whether or not someone can drift in and out of the Commonwealth as they please or when they please with a firearm. And it is a difficult issue, but again, balancing it against the Commonwealth's interest in regulating the flow of weapons over its borders is a very compelling interest.
Thank you.
Thank you.
Court